Brilliant Commercial Institute presenting shorthand dictation, legal and journal passages for upcoming SSC, PSC, Rail, High Court, District Courts exam at the rate of 80, 100, 120, 140, 160 and 200 words per minute. For acquiring 120 and 160 speed in a very short time, you should follow these guidelines. Practice this dictated passage 4 times at a stretch in a day. Practice each outline before taking dictation thoroughly and transcribe and check your transcription from dictated passage which I dictated in this video. Let's start. Challenge in this appeal is to the judgment of a division bench of the Kolkata High Court disposing of the writ petition. The appeal and the application filed with certain modifications on the allegations that there was insertion of a variant element in the meter to bypass recording of actual consumption. First information report was lost by the personnel of the appellant board. The provisional assessment was made and thereafter there was a disconnection of electricity supply. A writ application was filed by the respondent number 1 making grievance that the disconnection of the supply was wrongly done and the provisional assessment as made claiming rupees 2.5 lakh on the alleged ground of theft of electricity and or tampering of the meter was not sustainable. Learned single judge of the Kolkata High Court disposed of the matter in writ petition whereby and where under the appellants were directed to restore electrical supply on a deposit of rupees 20,000 by the writ petitioners. The appellants questioned correctness of the order on the ground that the disconnection of supply line was effected on 24/1/2006 in terms of the Regulation 52 of the West Bengal Electricity Regulatory Commission. The division bench referred to Regulation 52 and observed that the appellants have got the right to disconnect supply line of electricity on fulfillment of the condition stipulated, but the same is required to be done following a particular procedure. It was held that due procedure was not followed. The division bench held that under Section 126 of the Concerned Electricity Act 2003, the writ petitioner had a right of filing on objection thereof, which has been filed by the writ petitioner under Section 126 within bracket 3. The appellants are required to pass a final order after giving a reasonable opportunity of being heard. The writ petitioner also has a right to prefer an appeal under Section 127 of the Act against the final assessment order. The division bench therefore permitted the parties to pursue the remedy. It was however held that the disconnection of power supply was contrary to and was in breach of Regulation 52 and the writ petitioner was therefore entitled to be compensated. Accordingly, the cost of rupees 25,000 was imposed. Learned counsel for the respondent submitted that the High Court has taken note of the factual scenario and the legal principles applicable. The final assessment in any event is the subject to challenge. Since the final assessment has been challenged, we feel interest of justice would be best served if the same is disposed of in accordance with law. It is open to appellant board and its functionaries to highlight before the concerned authority as to the maintainability of the appeal on the ground of alleged delay. It is needless to say that the said aspect shall be considered by the appellate authority. Let the appeal be disposed of in accordance with law without being influenced by any of the observations made by the High Court in the impugned order and by learned single judge. Stop para. Challenge in this appeal is to the order passed by the division bench of the Punjab and Haryana High Court dismissing writ petition filed by the appellant under Article 226 of the Constitution of India 1950. Prayer in the writ petition was to quash the award dated 23/09/2004 under which the respondent number 1 was directed to be reinstated with continuity of service with 50% back wages within stipulated time. The award was made by the presiding officer Patiala. The matter was before the Labour Court on the basis of a complaint made by respondent number 1 para. The brief facts of the case are that respondent number 1 workman was appointed as bulldozer operator with the petitioner management on 01/11/1990. Since his appointment was on 89 days basis, the same was extended from time to time till 05/07/1996. Thereafter, his services were not extended. The workman raised an industrial dispute on the ground that his services were terminated by the management on 15/07/1996 without any notice, charge sheet, inquiry or compensation, and that the juniors to him are still in service of the management and new persons were also appointed by the management after terminating his services. The government referred the dispute to the Labour Court for adjudication under Section 10 (1) c of the Industrial Disputes Act 1947 and the Labour Court on 23/09/2004 made the award which was challenged before the High Court. The stand of the petitioner management is that respondent number 1 workman was engaged as a bulldozer operator on 89 days basis, and in that stop-gap arrangement he had worked from 1/11/1990 till 15/07/1996, but intermittently he was never employed continuously, therefore did not work for 240 days in the preceding 12 calendar months. Thus, the denial of further extension of his service does not amount to retrenchment, therefore has been wrongly awarded reinstatement with back wages. The Labour Court has not appreciated the fact that since the petitioner department is not an industry, the services of respondent number 1 were not governed by the aforestated Act. The Labour Court held that Section 2 (o) of the Act has no application to the facts of the case. In any event, the workman had completed 240 days of work in several years. The appellants took the stand that respondent number 1 have not completed 240 days of work in any calendar year. He never worked continuously. The employer was not an industry. The Labour Court held that there was no compliance with the requirement of Section 225F of the Act. The question whether department is an industry has to be decided against the management for want of evidence. The onus was on the department to prove that the workman worked only 180 days and not completed 240 days in the preceding 12 calendar months from the date of alleged by the department. The claim has to be accepted in the writ petition before the High Court. It was categorically urged by the appellant that no appointment order was produced. Stop. Thank you. Jai Hind. Jai Mera Bharat.